Welcome back to the OMB Law Board. I'm Simon Bennett from OMB Solicitors, and today I've got with me one of our associates, Sam Layani. Sam, welcome to the podcast.
Thank you. Thanks for having me on board.
Hey, Sam, economic pressures, cost of living is just hot topic at the moment, and a lot of people are owed money.
We see it a lot at the moment. A lot of the new client inquiries coming through the doors at the present are someone owes me a debt, or alternatively on the flip side, I'm in trouble. How do I get out of this? There's a lot of matters that at the present that we are taking on where individuals are trying to recover money from other individuals, and corporations also trying to recover money from other corporations.
Yeah, and it really affects my cash flow because I've done the work, or I've provided the services, or I've supplied the product, and I've got this money outstanding to me. So you're in the litigation team here. Let's run through some of the avenues that are open to me as an individual or a company when I've got these debts. So
Sure.
I come in to see you at OMB litigation team.
Yeah.
How can you help?
So I think first point of call is, are you an individual or are you a company? And who owes you the debt? So we'll always run through the basics and we'll get you into the office. And first point of call would be issuing a letter of demand. It's usually the first step in the proceeding.
Okay, and what is a letter of demand?
So a letter of demand basically is a document. It would set out the position, the debt, what is owed, and then it would go away with the payment terms, usually either 7, 14 or 21 days.
So an opportunity to resolve it.
Yeah, it's an opportunity to resolve it.
Okay.
Sometimes also it's used as a cost protection tool as well, because a letter of demand, as opposed to a commencing a legal proceeding, whether it be QCAT or within the magistrates, district or Supreme Court, is a cost-effective way and tool to recover a debt.
I see. So quite cheaply we can get through this process and get a letter out and
Yeah.
hopefully resolve the dispute.
That's right.
But we live in the real world and that doesn't always work. So what other avenues have I got if that doesn't result in me getting paid?
So it really depends on the debt itself. What is the value of the debt? We've got various courts in Queensland. We've got the Magistrate, District and Supreme Court, and there's obviously cost jurisdictions that apply to those particular courts. And we've also got the Queensland Civil and Administrative Tribunal, which is a in-person representative tribunal that people can approach themselves and we can aid through the process as well. So, for example, if you came to me for a debt and your debt was $50,000, we'd be in the Magistrates Court. And after issuing a letter of demand, being the first point of call, we draft a claim and statement of claim seeking recovery of the debt, interest and your legal costs in taking that step to recover the debt. So that would be your first step in the legal proceeding.
Okay, so if I do need to commence proceedings, at least as part of that process, I can recover my interest on the money that's unpaid and at least some of my costs if I'm successful in this action.
That's right. In Queensland and within our court systems, there is cost thresholds. They are prescribed costs, and there's also different recovery of costs. We have standard cost basis and indemnity cost basis, but costs we can discuss on another day. For today's purpose, really, a claim and statement of claim will set out the amount you're owed, the interest you're owed, and you can claim a portion of your legal costs in attending to that step. That's right.
So now let's assume we've had to start the process, we're successful. How do I enforce it? How do I actually get the money?
So let's take an example that you commence a claim and statement of claim and a defence is not put on within the 28-day time frame. Then you obtain judgment in default. How do we enforce that? Well, there's a number of ways. We could do a enforcement hearing to enforce the debtor to come to the party and enter into maybe a payment arrangement. They have to swear up a statement which lists their bank accounts, their assets, just so you have a broader picture of recovery, and you can apply to the court for a garnish order, maybe a payment of a sum of their wages over a period of time to recover it that way. There's a number of ways we can do about it, and that is one particular way we can recover money.
Okay, so there's a couple of options there. What about non-court recovery actions?
Right.
So I know this is a favourite of yours and it's quite an aggressive way to claim.
I mean, this applies not to individuals. This applies to corporations. It is a bit of an aggressive tool, and it is accredited statutory demand.
Statutory demand.
Yeah.
Okay. What's that?
So It is where a corporation, a creditor company, has a debt against a debtor company, and they issue a creditor's statutory demand in the prescribed form pursuant to the Corporations Act. As you said, it's a pretty aggressive tool, and within 21 days, the debtor has to either pay the debt, or alternatively, if they have a issue with the regularity of the form, or there's a genuine dispute as to the existence of the debt, they can raise that at that time. But it's an out-of-court tool that's commonly used.
Okay, so this notice, which can only be used in certain prescribed instances, I can issue against the company, and they've got 21 days to either pay my debt or what happens?
So if they don't pay the debt within a 21-day timeframe, or they don't respond to the creditor's statutory demand, it's a deemed insolvent event. So if they don't do what they're required to do within that 21 days, you can then proceed to the court and apply for a wind-up order, which would be placing that corporation wound up in insolvency. A trustee would be appointed, and the assets and liabilities would be governed by the appointed trustee in the wound up company affairs.
Wow. Okay. So that is quite aggressive, and as you said, will only apply in certain circumstances. So there's a number of different options available to us, from negotiated outcomes, simple letters of demand, actual court litigation, or statutory demands. So you've got a few tools in your shed to use.
Yeah, there's a lot
Sam.
of tools. Look, it's case by case. It's subjective. What is your end goal? Sometimes litigation is very costly. And so you have to really assess what avenue you're going to go down to attempt to recover this money. And, litigation inherently litigious. And it does take some time to get a court date. But in saying that, the best way forward is always to put as much pressure as you can in the out-of-court phase, attempt to resolve it so you don't incur those unnecessary legal costs in proceeding with a costly and what might result in a lengthy litigation.
So I know from calls that we've received here at OMB that some people's businesses can be crippled by a number of debts. They definitely should get in contact with you to set out a procedure or a program
Absolutely.
for recovery of those debts and improve their cash flow.
Absolutely. So talking about, for example, the creditor's statutory demand, if you are a debtor company that you have been served with a creditor's statutory demand, you shouldn't bury your head in the sand. It's usually at a time where the company affairs are in such a position that you're in a difficult state and difficult position. So you need to be front-footed. You need to seek legal advice very quickly. The 21-day time frame, for example, in that situation is a very cumbersome time frame, and you need to seek legal advice as to how best I can approach this, and do I have any tools in my own basket, being on a debtor company side, to try and navigate through that difficult time.
Well, thank you so much for your time today, Sam. I'm sure our viewers and listeners have really appreciated what is a really difficult area as cost of living pressures
Absolutely.
continue.
Yes.
And we appreciate you being here on the OMB Law Board.
Thanks very much for having me. Cheers.
If you do find yourself in the unfortunate position of having debtors crippling your business, contact Sam and the OMB litigation team to assist with their recovery.